Hello everyone and welcome back to your channel Lawpedia. This is me Jasmine, and in this particular video we'll be covering everything and almost all the main and important aspects related to your Medical Termination of Pregnancy Act, that is the MTP Act of 1971. So I hope you all remember, recall or know that one of the major amendments to the act was done in the year 2021 itself. So we'll be covering the amendment and one important case law, a very recent one, so that you understand the act with the help of an example in the form of a case law, that as to how it is actually applied. So basically आज की वीडियो में हम एक्ट को भी समझेंगे, we'll understand उसके basic and important provisions कौन से हैं, and a case law के means से we'll be completing today's video. Before moving forward, a small quote for starting today's video is, giving birth and being born brings us into the essence of creation, where the human spirit is courageous and bold and the body a miracle of wisdom. With this wonderful quote, we'll be starting off today's video. Now, firstly, in this, we'll be understanding Medical Termination of Pregnancy Amendment Act 2021. So अगर आप Amendment Act के special provisions को, that what all it changed को समझ जाते हैं, it is equivalent to understanding the act itself. So first and the very important amendment brought about by the 2021 Act was increasing the upper gestation limit from 20 to 24 weeks. So पहले जहाँ you could seek medical termination of pregnancy for 20 weeks only, now this has been increased to up to 24 weeks for special categories of women. Secondly, the opinion of one provider is needed for termination of pregnancy for up to 20 weeks of gestation, and the requirement of the opinion of two medical providers is needed for termination of pregnancy from 20 to 24 weeks of gestation. So इसका बेसिक मतलब है, if the pregnancy is up to 20 weeks, आपको एक मेडिकल प्रैक्टिशनर का ओपिनियन चाहिए जो कि गुड फेथ में कह सके continuance of such pregnancy would impact the physical or mental health of the woman. And in case the pregnancy ranges between 20 to 24 weeks, दो मेडिकल प्रैक्टिशनर का गुड फेथ में टर्मिनेशन ऑफ प्रेगनेंसी पे ओपिनियन जरूरी होगा. So now the new law contributed towards ending preventable maternal mortality to help meet the sustainable development goals as well. So बहुत सारे केसेस हमें ऐसे देखने को मिलते हैं जहाँ पे ड्यूरिंग गिविंग बर्थ द फीमेल अनफॉर्चुनेटली डाई बिकॉज ऑफ द लैक ऑफ द प्रॉपर डायग्नोसिस जो कि हो सकता था प्रायर टू गिविंग बर्थ, और जहाँ पे कोई फ्यूटल अबनॉर्मलिटी होती है that cannot be cured, or probably the fetus would eventually die within 1 or 2 years of birth, वहाँ पे मेडिकल टर्मिनेशन ऑफ प्रेगनेंसी एक बहुत ही इंपॉर्टेंट रोल प्ले करती है फॉर बोथ द मेंटल एज वेल एज द फिजिकल हेल्थ ऑफ द मदर. एंड कब ये टर्मिनेशन पॉसिबल होगी? दिस मे बी पॉसिबल इन टू सिनेरियोज. Firstly, whereby the continuance of pregnancy would involve risk to the life of pregnant woman or of grave injury to her physical or mental health. So अगर कोई ऐसा सिनेरियो अराइज होता है जहाँ पे ये प्रेगनेंसी कंटिन्यू करने से वुमेन को ग्रेव फिजिकल इंजरी हो सकती है या उसकी मेंटल हेल्थ पे इम्पैक्ट पड़ रहा है, उन सिनेरियोज में मेडिकल टर्मिनेशन ऑफ प्रेगनेंसी इज पॉसिबल. Or secondly, there is a substantial risk that if the child is born, it would suffer from any serious or mental abnormality. So यहाँ पे जो हम physical या mental abnormality की बात करते हैं, please make sure that it's very very serious as in detrimental to the health of the child born, him or herself. So अगर कोई बहुत ही ऐसी सीरियस प्रॉब्लम है जो चाइल्ड को हो सकती है, that means that may eventually lead to his or her death within few years being born, उन केसेस में भी मेडिकल टर्मिनेशन ऑफ प्रेगनेंसी को अलाउ कर दिया जाएगा. Now for the purposes of this act, whenever there is a pregnancy that occurs as a result of failure of any device or method used by any woman or her partner for the purpose of limiting the number of children. So in case the pregnancy is caused by failure of any method that may actually have been used to prevent or limit the number of children, the anguish caused by such pregnancy may be presumed to constitute a grave injury to the mental health of pregnant women. That means whenever there is a scenario whereby the pregnancy period does not exceed 20 weeks, so pregnancy period 20 weeks के अंदर है एंड ये प्रेगनेंसी कोई भी ऐसा मेथड फेल होने से कॉज हुई है जो कि यूज किया जाता है फॉर लिमिटिंग द नंबर ऑफ चिल्ड्रन, that will be treated as a grave injury to the mental health of the pregnant woman. And where the pregnancy that is alleged may have been caused by rape, the anguish caused to the pregnant woman shall be presumed to constitute grave injury to her mental health. Further, the upper gestation limit will not apply in cases of substantial fetal abnormalities diagnosed by a medical board. So now ये basic फीचर ये कहता है जहां पे भी एक मेडिकल बोर्ड कॉन्स्टिट्यूट होता है एंड द बोर्ड discovers certain substantial fetal abnormality. So now the important word is substantial, यानी कि abnormality इतने level पे serious है, that means if the fetus, if the child is born, his or her health would itself be in danger, let alone keeping the health of mother in danger. That means the abnormality not only would impact the woman's health but would impact the fetus's health, impact the health of the born child as well. So in such cases 24 weeks की लिमिट को भी इग्नोर करके मेडिकल टर्मिनेशन ऑफ प्रेगनेंसी को अलाउ किया जा सकता है, दैट ओनली ऑन द एडवाइस ऑफ द मेडिकल बोर्ड एंड permission from the requisite authorities. And ECP we have covered one case to make it clear how does this happen. So now the other important factor covered by the Medical Termination of Pregnancy Amendment Act was the confidentiality clause. So now यहाँ पे addition हुआ section 5A का, that basically deals with confidentiality, maintaining the privacy of a woman. That means the name and other particulars of a woman whose pregnancy has been terminated cannot be revealed except to a person authorized by law. So कोई भी ऐसी pregnancy की details आप बाहर in general public को किसी और को नहीं बता सकते हैं except to the person who is authorized by law. Now, the amendment even extended the medical termination of pregnancy services under the failure of contraceptive clauses to unmarried women to provide access to safe abortion based on women's choices and irrespective of marital status. Moving forward, the Act also prescribes places where the pregnancy may be terminated. That means either it needs to be a hospital established or maintained by the government, or a place for the time being approved for the purpose of this act by government or a district level committee constituted by that government with the chief medical officer or district health officer as the chairperson of the said committee. So now in places पे ही you can terminate the pregnancy. Moving forward and understanding certain basic punishments prescribed in the act. So now act provides that notwithstanding anything contained in the Indian Penal Code, termination of pregnancy by a person who is not a registered medical practitioner shall be an offence punishable with a rigorous imprisonment for a term which shall not be less than 2 years but which may extend to 7 years. So यह act ये कहता है, if the person performing the termination of pregnancy is not a registered medical practitioner. Registered medical practitioner कौन होते हैं? ये वो लोग होते हैं जो कि एक मेडिकल प्रैक्टिशनर हैं who possess any recognized medical qualification as defined in section 2 of the Indian Medical Council Act 1956, whose name has been entered in a state medical register and who has such experience or training and gynecology as may be prescribed by the rules under the act. So ऐसे कोई भी बंदा जो कि ये requisite qualification है, जिनको ये experience है, जिनका नाम registered है, अगर उसके अलावा कोई भी बंदा performs the medical termination of pregnancy such a person may be punished up to 7 years under the Act. So, moving forward, the Act also prescribes that protection of actions taken in good faith. No suit for other legal proceedings shall lie against any registered medical practitioner for any damage caused, likely to be caused by anything which is in good faith done or intended to be done under this act. So कोई भी ऐसे steps जो कि good faith में लिए गए हैं by the medical practitioner, उनके खिलाफ you cannot initiate legal proceedings if they do not lead to the desired consequences. That is the basic gist of medical negligence as well, and we have covered that in our previous video. If you haven't watched that, you can go ahead and see that as well. So now moving forward in understanding a recent judgment of Delhi High Court of January 2022. So basically इस case में the female who approached the court was actually 28 weeks pregnant. That is much beyond the maximum limit, that is 24 weeks. इस case में the petitioner's case was that if the pregnancy is taken to its logical conclusion, that means अगर ये pregnancy से the female delivers the child is not likely to survive beyond 1 year, and that too with the continued medical assistance, which will not only cause severe harm to her physical but her mental health as well. So ये basic facts थे इस case के, that if the pregnancy is taken to its culmination or its conclusion, जो fetus born होगा would be able to survive for maximum 1 year. That was the substantial fetal abnormality diagnosed and observed in this particular case by both the court and the medical board as well. So now the Delhi High Court allowed the medical termination of a pregnancy which ranged to 28 weeks of a 28-year-old woman after taking note of her mental and emotional distress. So in this particular case, court ने ये conclude किया that if the petitioner is forced to continue with the pregnancy, she will not only constantly live with the fear that the odds of giving birth to a stillborn are very, very high, but that even if the infant is born alive, she will be raising the child with the heavy pain of knowing that she could lose the child forever within few months. So that was one of the most important observation of this particular 2022 judgment by the Delhi High Court. इस केस में medical board constitute हुआ था. Medical board gave its full report and made the female very much aware with the consequences of termination of pregnancy. That means अगर आप 28 weeks पे pregnancy को medically terminate करते हैं, उसके अपने repercussions भी हो सकते हैं, both physically and mentally on the health of a female as well. It's not as easy to terminate as it may feel. The child that may be removed may even be removed alive, and यहाँ पे बोर्ड ने ये भी कहा while the medical termination of pregnancy is done, अगर जो child remove करते हैं that child is born alive, it will be the duty of parents to take care of the child for however long the child would live. Despite that, the court actually granted the female to go ahead with the medical termination of pregnancy, and understanding all the consequences and her choices, all the repercussions, all the medical and legal implications, only then a female can go under medical termination of pregnancy. So with this, we come to the end of our video. I hope you did understand some of the very important aspects related to medical termination of pregnancy. If you have any doubts related to the concept or any other thing, you can of course reach out to us via the comment section and put in all your doubts in the comment section below. We will of course reach back to you. And as we always say, please stay home, stay safe, and keep learning.